Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the recent decision from the Supreme Court of Canada upholding Premier Doug Ford's decision to reduce the size of Toronto City Council. Premier Ford said he wanted council shrunk for cost savings and to improve efficiency. But Ford's decision was extremely controversial because he made the move when the Toronto municipal election campaign was already underway. Candidates needed to scramble to adjust their campaigns to 25 wards instead of 47 wards. The case went all the way to the Supreme Court, which has now held that the move was constitutional. Here today to talk about how we got here and what all this means are three legal experts. Joanna Barron is the Executive Director of the Canadian Constitution Foundation, the same charity where I work, and the CCF was an intervener in this case. Jacob Klugsberg, a lawyer with McCarthy Tetrout, is also joining us, and he represented the CCF in this case. And we're also joined by Mark Mancini, a lawyer and PhD candidate at the British Columbia School of Law and author of the Double Aspect blog and former director of the Runnymede Society. Thank you all so much for joining me today. Let's start with the background of the case. Mark, what was the basis for the city challenging the Premier's move that this was unconstitutional? What arguments did the city make?
Well, Christine, thanks for having us on today to talk about this issue. The city basically made two arguments when they brought this case to the lower court. The first was that Ford's move to reduce the number of wards in Toronto violated the written freedom of expression in the Charter of Rights and Freedoms. And then number two, they made a bit more of an abstract argument that the reduced ward structure violated what they call the unwritten principle of democracy. So we had really two arguments here, one based on the written part of Canada's Constitution and one based on the unwritten part. And I gather we'll talk about some of the differences in those arguments as we go along with the segments here.
Yeah, absolutely. So Jacob, what arguments did the province make at the lower level justifying the decision to reduce city council size?
So ultimately, there are two parts of the province's argument. One was the kind of rationale behind it, that they wanted to create a more efficient city council by reducing the number of wards. They wanted to save taxpayers money, and they wanted to increase voter parity, which the previous ward structure didn't do. And then they had the legal arguments where they said, really, their legislation regulates municipal governance and the council composition, not freedom of expression. And according to the province, that was entirely within their right under the Constitution. They also said that Section 2B of the Charter, which guarantees freedom of expression, does not guarantee that that expression will actually be effective. Their final kind of main argument was that Section 3 of the Charter, which guarantees a right to vote and also contains kind of the principle of effective representation, only applies to provincial and federal elections. It doesn't apply to municipal elections.
Yeah, that's a great point because, as we know, there are specific parts of the Charter that protect our voting rights, but only with respect to those two levels of government, not to municipal governments, which are creatures of statute. So, Joanna, what the lower court found was surprising for a lot of people. They've held that this move by Ford was unconstitutional, and it was on the basis of freedom of expression. So can you elaborate on what the lower court judge held in that case?
Yes, so raised many eyebrows, of course, and he held, Justice Belobaba of the Superior Court held that Section 2B, first of all, protects municipal elections in spite of there being Section 3, which explicitly protects federal and provincial, but not municipal elections. And he seemingly held that not only did it protect municipal elections, but it protected a specific ward structure. In other words, the transition from 47 to 25 wards was unconstitutional. And so we know that we have a general guaranteed freedom of expression, but the notion that it could extend to a specific configuration of wards in a municipal election struck most legal observers as highly bizarre.
Yeah, I know. I was involved in that case when I was with a different organization, Canadian Taxpayers Federation. And ultimately, the election did proceed with the smaller ward structure because the Court of Appeal overturned that or at least suspended the decision and allowed the election to proceed. They ultimately had a ruling that came later after the election had taken place, and we're going to get into what they held in that ruling at the Court of Appeal level, and then ultimately at the Supreme Court when we come back from this commercial break. Welcome back to Canadian Justice, where we're talking about the recent Supreme Court decision upholding the reduced size of Toronto City Council as a constitutional move by Premier Ford. So, Jacob, this went all the way to the Court of Appeal and ultimately to the Supreme Court. So can you elaborate on what these other levels of court held about whether freedom of expression was engaged by reducing the size of City Council in Toronto?
So both the majorities of the Court of Appeal and the Supreme Court. So in the Court of Appeal, it was a 3-2 split, and in the Supreme Court, it was a 5-4 split. So 5 judges ruled that Ontario's legislation imposed no limits on freedom of expression. And what they found here in a big portion of this case came down to the timing of the provincial government's decision. And what the majority found specifically in the Supreme Court was that there was adequate time after the legislation was announced and the new structure was created, in fact, 69 days for candidates to reorientate their message and to convey their message to voters. And these 69 days is, in fact, longer than a lot of provincial and federal elections have been. And the court found that this amount of time did not radically frustrate voters or candidates' freedom of expression, and did not effectively preclude their ability to have meaningful expression. The court gave the example that had it been only a 2-day election period, for example, that could have been enough to frustrate and preclude meaningful expression. But given the amount of time, that wasn't the case. The court also found that by changing the structure, they may have been making some candidates' expression less effective, but that's not one of the guarantees under the charter. And finally, as we talked about before, the court confirmed that Section 3, which guarantees the right to vote, does not apply to municipal elections and cannot be subsumed by Section 2B under freedom of expression.
Yeah, it certainly felt like the city was trying to sort of stretch or twist what some of our charter guarantees are in order to fit their case or what outcome they wanted into those rights. And Joanna, I know that you had a lot of concerns with that type of argument. What can you say about your concerns about what the lower case held, and also on how quickly this case moved?
Yeah, so I think Jacob laid it out clearly that essentially the judge, Belababa, imported these Section 3 voting rights into the freedom of expression charter right in order to circumvent the decision. And effectively, there's a clear legislative decision in Section 3, right, to protect provincial and federal, but not municipal decisions. And whether we like that or not, we've got to either put it up for constitutional amendment or live with it. And then once he had done that, he gets into this very granular question about what award should be, what award structure should be in order to comply with the Constitution. And it seems to essentially come down to timing. He talks a lot about notice and this happening mid-election, but it seems like it would have been even worse if the government had done this after the election, for example. In terms of timing, of course, obviously the Court of Appeal issued its stay very quickly, probably because of the timing of the election. And from there, the question was somewhat moot because obviously we weren't going to void the Toronto City election. And then it proceeded along longer lines because there obviously are perennial constitutional issues, which we'll continue discussing, arising from the decision.
So the timing has been a big part of what this lower court decision was. Mark, do you think if this had happened outside of the campaign period, for example, if the premier made the amendments a few years before an election, do you think we would have had any of this go to court?
Christine, I think that's a very interesting question, but I really do think the factual context here, the fact that it happened during the election, was what really gave the challenge some teeth. That's only because we know that, as Joanna said earlier, municipalities are just creatures of the province. The province basically has entire control over the makeup and structure of municipalities and their councils. And it was the specific fact that the province chose to exercise that power during the election that kind of gave rise to the argument Jacob was talking about, where the candidates were arguing that their right to make representations and to campaign in the city were violated. So without that context, without that election happening, the issue kind of loses some of the power. Now, I think it still would have been a controversial move, to say the least. I think if there may have been a constitutional challenge, even if it happened before the election. But again, the timing here is what was really at issue, I think, in the lower court and certainly in the dissent at the Supreme Court of Canada.
Welcome back to Canadian Justice, where we're talking about the decision by the Supreme Court of Canada upholding that the Premier of Ontario could reduce the size of Toronto City Council and that move was constitutional. Now, Mark, one of the biggest things coming out of the case was about whether what are called unwritten constitutional principles can be used to invalidate legislation. So let's get back to basics for our viewers. What exactly are unwritten constitutional principles and what role do they play in our Constitution?
So when we talk about the Constitution of Canada, people, me included, often think, it's a written document, and that's partially true. There's a written document, that's partially the charter, but the Supreme Court has also recognized that part of Canada's Constitution is unwritten, and it said that there's 4 unwritten principles of Canada's Constitution that can come into play, and those 4 principles are democracy, the rule of law, constitutionalism, and protection of minorities. So we know that Canada's Constitution is a mix of these things. What's unclear, though, is whether or not a court can rely on these principles to strike down legislation. We know that a court can rely on the text of the Constitution to strike down legislation. We've seen that in all sorts of cases involving medical assistance in dying, prostitution, and the like. But we don't really know if these principles can be used to strike down legislation, or are they just used to kind of fill gaps where the constitutional documents are unclear. So this has been a question on which there's been a lot of division, and this case is, I think, partially set up to deal with that division.
So, Joanna, what do you think our viewers should understand about unwritten constitutional principles? Like, for a non-lawyer, it might seem pretty theoretical. So what's the practical importance of the issue for regular Canadians?
I think the big issue is that they are theoretical, they are unwritten, they're general and abstract, as Mark described, democracy, the rule of law. These are broad concepts. And in terms of their import in a particular context or case, they can only be ascertained or almost like divined by judges who are fairly cloistered, who are unelected, not democratically accountable, and they're not available for ordinary citizens like you or I to read or be informed by. So aggrandizing the role of unwritten principles is a very shaky proposition, in my view.
So, Jacob, the CCF made arguments about unwritten constitutional principles in this case and the role they should play. What were those arguments?
So the CCF argued the reason we have a written constitution is because we made certain choices as a country of what would be protected and what wouldn't be. And what the CCF argued is that the court can't rely on these unwritten constitutional principles, which are not actually provisions of the Constitution, to find that laws are invalid or to expand the scope of what existing rights are beyond what's actually prescribed in the Charter and the Constitution. So essentially, if there are gaps in what the text says, there may be a role for unwritten principles to fill that gap. But when the text is clear, as the CCF argued, it was the case in here in City in Toronto, there's no room for unwritten principles.
So, Joanna, what did the Supreme Court ultimately decide in this case about the role of these principles?
Well, the CCF was very happy with the majority's decision. We agreed with it entirely. They said that unwritten principles cannot be used as a base for invalidating written legislation. And they said charter interpretation or interpreting the law has to begin and be rooted in the text and that unwritten principles are part of the law, but in the sense that they form the context for interpreting the written laws, but they cannot be a freestanding basis to invalidate written laws.
Yeah, so that was a great result that our organization got. But this was a close case, and there was a forceful dissent that was written by 4 of the justices. So, Mark, what did the dissent say about the role of unwritten constitutional principles? We've got about a minute in this segment.
Yeah, so the dissent, in short, would have allowed the unwritten principle of democracy to violate to reject the reduced ward structure here. So they would have said that we can use these unwritten principles to strike down legislation. As Joanna said, that's a very, in my view, a difficult proposition to support. These principles are very abstract. They really can mean many, many different things. They're unclear. And I think there's a real rule of law and predictability problem if these sorts of principles can be used regularly to strike down legislation.
And certainly it's concerning that it was such a close case. When we come back from this commercial break, I want to ask you about what it means that it was so close, and if it means that this is actually really not settled ultimately at the end of the day. We will be right back. Welcome back to Canadian Justice, where we're talking about a recent decision by the Supreme Court upholding that Premier Ford could reduce the size of Toronto City Council and that move is constitutional. So, Joanna, this case was close. It was 5-4 on whether unwritten constitutional principles can be used to invalidate legislation. What does this split tell us about where the court is on this issue and whether this question is truly settled?
Settled. The only thing that we can know for sure is that we're going to continue having this debate. Judges retire. They have a mandatory retirement age. So if we had a different shuffle, then the answer could have been different. One judge away. One judge cast the tie-breaking vote on this very central question, which is whether judges can create their pure judicial law, which are not amendable, right? Even if everybody in the country, federal and provincial actors, decided they wanted to change something, this is pure judge-made law. And we are that close to bringing in pure judge-made law in this country.
So, Mark, same question to you. What do you think this decision means for the future and about whether it is settled about whether or not unwritten constitutional principles can be used to invalidate legislation?
Yeah, so I'd say 2 things. I think the first is that the decision reinforces what the Supreme Court has done recently when they're interpreting the Constitution. And that's to say that we're really focused on discovering what the text of the Constitution means. We aren't focused on what a judge's particular policy preferences are, or what the judge wants the text to mean. We have to start with the text, and the majority makes that clear. The second thing I think, though, is, I agree with Joanna, the door is left slightly open to the use of unwritten principles. The majority says we can use them to gap fill legislation, as I mentioned earlier, even though they can't be used to invalidate it. Now, whether there's a difference here, who knows? In reality, it may be that unwritten principles are actually still used in arguments. But at least for now, we have a bit more guidance on when they can be used and when they can't be used.
So, Jacob, what is your opinion? What do you think the long-term impact of this case is going to be?
I completely agree with Joanna and Mark, and I think, well, the facts of this case are obviously unique, and I think it's unlikely that we'll have a similar factual scenario come up to the Supreme Court. The issues that are at the heart of this case, like unwritten principles, freedom of expression, and the role of municipalities, that debate is sure to continue. And I think especially with municipalities who have now been told by the Supreme Court that they're at the legislative mercy of provinces under the Constitution, and really confirm that, I think we're going to have more of a discussion on that. Municipalities and their influence continue to grow. For example, the City of Toronto's operating budget is more than a lot of provinces and territories across Canada. And I think that what impact that has on their role within the Constitution is going to continue. And whether that ultimately leads to, the people, talking to their legislative officials and seeking an amendment to the Constitution to include municipalities, Who knows? But I do think that conversation is going to continue.
So Jacob, Joanna, Mark, I obviously agree with most of you. We all have been involved to some degree in this issue. But to play devil's advocate briefly, Jacob, I'm going to throw this question to you. Some critics have said that this decision is bad for democracy. It undermined democracy at the city level. What's your response to that in about 30 seconds?
Well, I understand that critique. I think what the majority did here, which is really commit and emphasize the importance of the constitutional text, will actually be good for democracy and civil liberties in the long run. Because if you care about protecting civil liberties, you have to be disciplined about interpreting the charter, interpreting the Constitution. Because the more that rights are clearly defined and you have clarity around that, the more likely that rights are going to be balanced and are going to be left to the legislative will or the people rather than, as Joanna mentioned, unelected judiciary.
Excellent response. Jacob, Joanna, Mark, I want to thank you all so much for coming on today to share your expertise. We've heard today about the recent decision by the Supreme Court to uphold Premier Doug Ford's move to shrink the size of Toronto City Council. Whatever you think of the politics around the move by Ford, which I personally think was poorly timed and potentially fueled by his own personal history with City Council, the fact is that it was within his authority to do, and the Supreme Court has held that. For me, the big takeaway in this case related to the role of unwritten constitutional principles in our system. While I'm happy with the result that unwritten principles can't be used to invalidate legislation, I'm deeply troubled by how close things got in this 5-4 decision. The issue is likely not settled for good. That's all for this week. I'm Christine Van Gyn. Thanks for tuning in. And remember, a freer Canada starts with you.